Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 29-year personal injury lawyer, and this is the podcast where we talk about all things personal injury law related. And up today, we're going to continue our discussion about the workers' compensation system. On the last episode, which was the first of this three-part series, we talked about what work comp is, what it isn't, and where the frustration arises when somebody's been hurt at work. They have expectations of what the system is or what they think it should be. And then they learn the reality. They learn that the system is limited in what it compensates, because a lot of people go into the process when they've been hurt at work thinking, okay, my medical bills are going to be covered. If I'm missing time from work, I'm going to get benefits for that. I'm going to get paid for missing work. And a lot of times people don't even realize the third step, which is that they're entitled to a disability settlement. And if they do know about that, they very well have expectations around what that's going to look like. For example, a lot of people think that they're going to get pain and suffering as a result of a work injury. And as we talked about in the last episode, that's not the case. So again, we addressed that the overall picture of a workers' compensation claim is it's not emotional, it's mathematical. It's all set. There's formulas, there's ways that we come up with dollar amounts. And as far as medical treatment and weekly benefits, they're not always automatic. There's an insurance company there. They have to approve treatment. Everything can be slow. You can be not getting the treatment you think you should be getting. So again, we covered that in detail, and we'll put that up at the end on the screen up here so that you can click and catch that episode if you missed it. But now today in this episode, we're going to talk about the first 90 days of a Missouri workers' comp claim and what helps, what hurts, what sticks. And again, on the Kansas side, a lot of this is very similar as well, but Kansas does have its own procedures and rules. But today I'm going to focus on Missouri because, again, very similar, gives you a good overview of what's important when an injury happens at work, what you want to make sure you're doing, what you want to make sure you're not doing. And so you got to keep in mind this overriding theme. Early records become permanent. And so things that are happening at the beginning are very critical to the long-term resolution of your work injury claim. And again, there's usually a lot of confusion. People that are hurt at work don't really know the system because this is the first time they've ever encountered it. You know, what I would say is they want to be cautious, but it can all feel very overwhelming. And so we're going to try to break this down. So a person that's hurt at work has a really good foundational understanding of what's really important in those first 90 days after an injury at work. So why is it that the first 90 days quietly decides the claim? You're going to have to understand that this is where many workers that have been injured can feel blindsided later on in the process. And early assumptions can become truth in the file. And I'll break that down a little more. But the difference between what feels important versus what is actually going to stick later on, that's what we've got to expand on so somebody really has a good understanding of this process. And so you got to remember this, the system doesn't forget, it just stops explaining. And adjusters and doctors, they lock opinions in early. So when you're sent to the work comp clinic and you are making your complaints about your injury, those doctors that, again, as I explained in the first episode, they're hired, they're paid by the insurance companies. And so, their opinions, that's what's going to matter going down the road. And credibility, your credibility as the injured worker, it's assessed long before any disputes arise in the process. So let's start with the very first thing that shapes everything: how the injury is reported. So, what you have to understand is in Missouri, you have 30 days to report your injury to your employer. And I can't stress that enough. A lot of injuries are very self evident. They're something that happens on the work site. There's witnesses, there's an immediate reporting process. And okay, that's pretty straightforward. But sometimes, for various reasons, injuries occur and it doesn't get reported to the employer. And that is a problem. And you have to know that. You have 30 days for an official notice to be given to your employer. And Missouri law requires that notice be in writing. So, one way that can occur is with an incident report filled out by some type of management person, HR person, something like that. And if that doesn't happen, then you, as the injured worker, have to make sure to put something in writing to your employer, identifying when this happened, how it happened, what was injured, all those critical details. And again, we can talk about HR forms that are actually used, how supervisors can paraphrase injuries, and why short descriptions are dangerous. So you want to make sure that you have input into what is being reported, because again, that can affect things down the road. We run into situations where we end up in a fight because somebody claimed an injury to a body part but didn't necessarily dial it in to even a more specific body part, or how it happened isn't exactly clear. There's not good detail in exactly what happened to cause the injury. It's just these little things like that can really affect the progress of the work comp claim as it proceeds. And so, things to keep in mind, I've already talked about timing requirements, 30 days, very important. You want to report anything. If you think you got hurt at work, you better report it, because it's one of those things where if you're like, I don't want to ruffle feathers, I don't want to create a problem, whatever's going on in your mind, that can be a problem. Because if you wait past the 30 days, now all of a sudden this injury you had has become a big problem for you. And you're like, I'm going to go ahead and tell my employer because I just can't continue working. I need to get medical care, whatever that looks like. And you're outside that 30 days, that's going to be a problem. They're probably going to deny the claim, and legally they can do that. And now you've got a problem because you can't get the medical care that you need. So keep that in mind, crucial. And again, when the report is made, minor language can become legal ammunition for an insurance company. Because again, if the report indicates more of a minor injury and later on this thing has developed into a much more serious situation, that insurance company will rely on that initial report. And they'll say things like, they talked about having a bump into something and it caused some bruising on their leg. And now they're claiming that they tore something in their knee with this incident and a surgery is needed. So again, you got to watch how that gets reported. But there's a difference between an injury, an aggravation, and repetitive trauma. So again, it's very easy, right, to understand an immediate injury, somebody gets their arm broken, very clear. there's not going to be much question there. An aggravation, say you have some underlying situation, spinal condition, and you're working and you end up aggravating that underlying condition. That changes things. And then repetitive trauma, you've done the same job for years and you have developed some problem with your body part because of doing this repetitive motion job. Again, we see that a lot with arms, wrist, shoulders. You've been doing this same job over and over time. It has developed. It's very critical the way that's reported, because if you come in and you say, my shoulder's hurting today, and they're like, okay, what happened? Nothing in particular. It's just really started hurting me today. And they're going to deny that claim. But if it's been something that has bothered you for a while and you've been doing that same job for a long time and you report it as this has been progressively getting worse back to whatever date that you can pin it on when it really started to become a problem, that's a repetitive trauma, and that is a compensable claim. So again, it's really important how that gets reported. But what I see a lot in the mistake world of how injured workers report these things is waiting because, the employee doesn't want trouble. They're worried about ramifications from their employer. And again, I know that's a really sticky place to be in, but you have to make the decision. Are you going to try to keep working through this, or are you going to report it to try to get help so that you're not doing further damage to your body? And you always have to remember there are other remedies. If your employer doesn't abide by the law, there are other remedies available to you. And if you report it and you start facing discrimination, harassment, retaliation for making that work comp claim, again, you have a separate potential cause of action against your employer. So there are protections in place in that instance. Now, the other thing is I see as a mistake reporting pain, but not the mechanism of the cause of the pain. So again, showing up to your employer, telling them that you're experiencing pain in some body part, your shoulder, your knee, whatever that looks like, and you have no reason for why that's happening, that's probably going to be denied. You have to have a factor involved in your work that has caused you that pain, that there's an injury there and it's related to something that you've been doing at work. So very critical to remember. And again, the other mistake I see is assuming verbal notice is enough. Assuming you telling somebody in management about your injury, that you want to make this claim and that it's going to get done and that you've preserved the claim, that's a mistake. You have to make sure you've put it in writing. And if that's an email to management, if it's a piece of paper written out and you keep a copy and you show that it was given to them, it has to be in writing. Just remember this, if it's not written down correctly, it didn't happen. And I see it. I see it a lot where the employer / insurance company comes in and they're like, we didn't have a proper notice. We're not covering it as a work comp claim. So now let's talk a little bit more about employer doctors. Again, I've talked about the fact that these doctors are obviously not doctors that you've chosen. These are doctors that are hired by, paid for by the work comp insurance company. So these aren't people that necessarily have your best interest at heart. They're involved to address the situation. And a lot of times their goal is to get you back to work. And at the same time, they're the ones that are in control of the narrative. So you've got to remember this is the critical part, that these doctors are not your best friends. And this is where most workers lose trust in the system, because they immediately start to feel this disconnect between the medical professionals they've been sent to and themselves, and the injury that they're experiencing and the treatment that they believe they need. And it happens all the time, because that's the calls I get. It's people saying they've sent me to this clinic and they just keep stringing me along. I'm not getting better. I feel like I need some more involved intervention and I'm not getting there. And so this is a real point of concern for injured workers. But you got to remember this, these medical opinions that these doctors give, they drive everything. The insurance company, this is what they get to hold up when they're talking to you and telling you why you're not going to get more treatment, because these doctors, their opinions are what they rely on. So it's just really critical. And the employer doctors, again, like I just said, they're balancing, in theory, providing treatment for the injured worker, but also getting you back on the job. There's that pressure point there for them. And conservative care is the gold standard in work comp. Whereas you might go to your doctor, say you hurt yourself working in the yard, and you might go to your doctor and your doctor's, I think you may have a torn rotator cuff in your shoulder. We're going to get an MRI. We're going to look, see if that's what's going on. If you get hurt at work, same situation, you've hurt your shoulder. The first things out of the doctor's mouth are not going to be, we're going to get you an MRI. It's going to be, okay, give you a couple days off work, give you some medicine, and we'll see you back next week. And then next week comes, you see them, same complaints, maybe worse complaints. And they say, all right, we're going to give it another week. We'll give you a few more days off work. Here's another script for some medicine. Again, the next week comes, same deal. Okay, maybe we're going to put you in some physical therapy for a little bit. Meanwhile, if there was an MRI done at this point, probably would have been done in a 3-week period, you'd have some real answers about what's going on in your shoulder. And then that might escalate it to, we need to get you to a specialist, because you very well may need surgery to address this. But a lot of people I see, they end up in physical therapy. It's making it worse. They're not getting better. They're getting worse. It's very painful. So then they're back at the work comp doctor. And maybe at that point, maybe a month, maybe longer, that doctor says, okay, we're going to order an MRI. And then you wait 2 or 3 weeks to get the MRI done. And then you wait a couple of weeks or so to hear the results. Meanwhile, you've been dealing with this injury now for 2 months, maybe longer. This is where frustration really sets in. This is where we get a lot of our calls, because people, they just realize this doesn't seem to be going as well as it should be going. I'm not getting better. I'm getting worse. Nobody seems to care. And that's the reality of the work comp system. And again, these return to work notes that doctors write, again, put you off for a couple days, put you off for another couple days, whatever it is. You're sitting there, you can't use your arm because you have so much pain and limited mobility. And this doctor keeps writing these notes, only giving you this little bit of time off. And those notes, they control the employer / insurance company's ability to force you back to work, because they only have to provide you weekly benefits if you're off work or if you're under restrictions that the employer cannot accommodate. So in other words, if the employer gets those restrictions and they say, we have no job for this person to do with these restrictions, okay, then work comp has to provide benefits. But if they're writing restrictions and the employer says, we can accommodate them, I see this a lot where they give the restrictions to the employer. They're like, sure, we can accommodate that. We'll have a spot for you. And then they try to work people outside the restrictions. So all of this is reality. This is what happens every day when people are injured at work. Red flags that you need to keep in mind. Pain dismissed as a subjective complaint, right? Again, you're complaining about pain in a body part. And the doctors are basically saying, yeah, that's normal. I mean, you strained this body part. It's normal to have pain. It'll get better. No imaging ordered. Again, what I just talked about. You can't get that MRI to rule out a more significant injury. Again, very frustrating. And then the sudden release to full duty. So here you are feeling like you're going backwards, you're not getting better, you're getting worse. And this work comp doc says, you're done. We're putting you back to full duty. And now you are in a situation where you really can't do your job. You can't go to work, but you have no legitimate reason not to be going to work. And you face getting fired. And this is where the whole system can really feel like it's crashing down on you because you just don't know how to handle it, where to turn, how to navigate this. So this isn't about good or bad doctors. I'm not making any comment on the doctors that are hired by work comp insurance companies. It's about a controlled system. It's a system that values getting people back to work and not necessarily addressing their injury fully and completely. So let's talk about work status, light duty, and wage benefits. Again, this is really where panic can set in for an injured worker. Workers feel punished for trying, right? Like they go to work, they're trying to work through it, and then somebody comes in and says, well, looks like you're doing your job. We don't see the problem. But it's because, again, you're being forced into that position. Whereas if you were getting the appropriate care and the appropriate consideration, you'd probably be off work. But again, that would require them to pay benefits. And light duty, again, you're on these restrictions to where you're supposed to only be involved in light duty type activities. Again, that can help or that can hurt because you can go and if they're keeping within those restrictions, great, but they can also argue you're able to do all this stuff. And so looks like you're progressing fine. And so again, it can be helpful to try to keep you on the job getting your full wage, but they can also try to put you, we see this where the employer says, we don't really have anything that they can do, but they can go work at a thrift shop. We have a partnership with a thrift shop where they can go, they can work inside their restrictions. And then they get to the thrift shop and it's, you can sweep floors, you can load clothes into boxes, you can do things. It's, whoa, hold on a second. This is more than what I would be doing at my regular job. At my regular job, I sit there, I'm creating plans, I'm working on a computer, all that stuff. Now I'm doing much more physical work than I would be in my normal job. So again, light duty is a real catch 22. Again, it can be helpful, but it can also essentially be used to not help you. Now, what happens when employers say we have work, but it's not realistic? And again, I've talked about that. They say, yes, we can accommodate you. And then again, they try to work you outside your restrictions. And it happens. Again, that's not allowed, right? And that's something that needs to be addressed immediately. And the problem is, if you don't have an outside person to help you with that, it's you against your employer. And now you're running the risk of facing termination from your job because they're going to argue, no, we're keeping you within those restrictions. So you need to be doing that job or you're going to be let go. Benefits that come along, they come in different variations. There's temporary total disability benefits. There's temporary partial disability benefits. And all that means is those are the weekly benefits that you're supposed to get when you are off work by the work comp doctor. Another thing to keep in mind is this. Sometimes clients go outside the work comp system to a doctor because of their frustration. They're like, look, this isn't getting anywhere. I need to take matters into my own hands. So they go see their own doctor. That doctor can do all kinds of things, but for the work comp system, And for the work comp insurance company, the only thing that they have to consider is what the authorized work comp doctor does. So your personal doctor can say, you need to be off work for 3 weeks. You need an MRI. You need this, that, whatever it looks like. And the work comp insurance company does not have to listen to that. They are legally justified on relying only on the authorized work comp doctor, the one that they're paying for. But temporary total disability benefits, essentially, that means you're completely off work. So you're getting temporary total disability, meaning right now you cannot work at all, but it's temporary. You're not permanently disabled, you're just temporarily disabled. And what that looks like is 2/3 of your average weekly wage. And what is an average weekly wage? Essentially, they look at the 13 weeks before you were injured and they come up with the average amount that you were making on a weekly basis. And then you get paid 2/3 of that amount. 1/3 of it isn't there. And the idea is these benefits, they're not taxable. So in theory, it's taking out essentially what you would pay in taxes, things like that. Now, where it also really hurts, if you have deductions for health insurance, things like that, that's not happening. And now that's your responsibility to make sure those are getting paid if you want to continue with health insurance. And you talk about a real financial crunch. It's not good. The weekly benefits can be a lifesaver to keep you financially above water, but it does not in any way, shape, or form keep you where you were when you were making your full rate of pay. Temporary partial disability benefits, that means you're partially disabled. So maybe you're working instead of 8 hours a day, you're coming in for 4 hours a day. And so you've got a 4 hour loss. Temporary partial disability benefits are there to make up the difference, but only again to your average weekly wage comp rate. So essentially to 2/3 of your average weekly wage. So it's a really not good spot to be in where the doctor says, okay, we're going to put you on limited days, limited hours, whatever that looks like. Again, you're having to go in and do some work. And then the work comp insurance company is going to come in and make up the difference up to that 2/3 of your average weekly wage. So not a great spot to be in at all. And then what you got to know is what happens when restrictions exist, but the work doesn't. But again, people are put on restrictions. The employer says, we don't have any work for you. So at that point, you should be getting temporary total disability. And if you're not, that's a problem. And that's something that has to be addressed immediately. And fortunately, the work comp system does have some ways of speeding up addressing these issues. Again, if you have a work comp lawyer involved, there can be hardship mediations and hardship hearings on that specific issue alone. And those things are all set pretty quickly. They're expedited. But again, you just got to know what your rights are, what your rights aren't. Some of the common pitfalls in all of this are informal accommodations. So where the employer is saying they'll accommodate you manner, and then again, they're really not. And what does that look like? How does that affect you? What are your rights there? Missing paperwork. A lot of times you're waiting on the insurance company to get something moving on your benefits because they're saying we don't have the paperwork from the doctor, so we don't know what your restrictions are, so we don't know whether we have to pay you, and this stuff can drag on. Meanwhile, you're not getting any money coming in because you're not working, but you're also not getting any benefits. And then just assuming that these pay issues will sort themselves out in time, again, that can be a big problem, a big pitfall, because if you're not the squeaky wheel, that's what I always tell people. You have to be the squeaky wheel. You have to stay on top of these people. You have to wear them out, because if you don't, they're going to ignore you. And again, if you can't get it done, that's when it's time to obviously get a lawyer involved, because obviously what you've tried It's just not working. But just keep in mind, if it's not documented, it doesn't exist. And so you've got to have written restrictions, and you want a copy of those. If a doctor says they're putting you on restrictions, you say, I want a copy, because you want to be able to show your employer. You don't want to have to wait for the employer slash insurance company to get that report, get those restrictions, because then you're waiting and they don't have to pay you till they have them. Very critical to keep in mind. So let's talk about when the system can really start turning against you. Now, I want to walk through some warning signs that you might start seeing that will give you a good indication it may be time to get some help. And I want you to understand, if you feel like something's off in this process, your instincts are probably accurate. You're probably not imagining things. And so you've really got to take a moment. You got to really monitor this process, and you got to really see, is this moving along smoothly or not? Here's the thing, not every work comp claim is problematic. Okay. There are people that get to one of the work comp clinics, and that particular doctor does move things along in a much quicker fashion. But so many people run into this delay situation. And so you've got to be in tune to the feel of how this process is moving along for you. But what are some warning signs? Delayed checks. So when you're getting those weekly benefits, nowadays, most of them come in as direct deposits. And if those direct deposits aren't hitting in a timely manner, or if they are mailing you checks and they're consistently delayed, that's just a warning sign that things may not be going according to what the plan should be. Treatment that's suddenly denied. I have this quite a bit where somebody seems to be going along just fine. They're going, let's say they start at the work comp clinic. Let's say the work comp doctor at the clinic refers them to a specialist. The specialist, whether the MRI has happened already or whether the MRI may get ordered by the specialist, whatever that looks like, but the specialist says, this is a surgical situation, you need surgery. And all of a sudden, it's denied. And you're not really getting a clear answer why that happens. And a lot of times it can be traced back to the reporting, how the injury was reported. Now, all of a sudden, because of surgery is out there and there's going to be some big money put out by the insurance company, they start looking for reasons why they may not have to cover that claim. And they're going to go back to the very beginning, what I talked about earlier. They're going to look at, what did the injured worker say caused their injury? Where did the injury happen? Is it a covered area? And I'm talking physically. Is it a covered area of where we would be responsible for that injury? Is the injury something that really was caused by what they were doing at work? Or was it caused by just something that happened? You got to keep in mind, just because something happens while you're working doesn't necessarily mean that it's going to be related to your work. So if you're walking down the hallway and you stumble, you trip on your own feet, whatever, you fall, you get hurt, that's very likely not a work comp compensable claim. And again, they want to go back to how this was reported and see, did this really happen because of the job duties the employee had? Very critical. Surveillance rumors. If you start hearing that they do surveillance, that you've been under surveillance, anything like that, you got a problem, because now they're trying to catch you and they're looking for a way to deny the claim. Pressure to settle early. So you're going along and all of a sudden they are shutting down and they're like, hey, look, we don't really think this is related, and we're willing to just make you a little bit of a settlement offer here to close this out. Obviously, big red flag. There's something off track, and you're probably going to want to talk to a lawyer at that point, because you're probably getting ready to be booted off the work comp benefits. But you got to remember this: getting legal help, calling a lawyer, again, it's always a free call just to talk about the situation. The other thing is, a lot of people worry about getting a lawyer and what that's going to look like to their employer. They're worried that if they get a lawyer involved, this is going to create big problems at work. But I always tell people, number one, you already have a work comp claim going. You're already a problem for the employer. So the fact that you get a lawyer involved in your work comp claim that's already on file doesn't really change anything. It can really only help you because now you have somebody there to watch your back, and you're not suing your employer. You cannot sue your employer for a work comp claim. You make a work comp claim. You've already made a work comp claim. So now all you're doing is getting a lawyer to enter into that work comp claim to act as a middleman and to push for what you should be getting in that work comp claim. So it's a great way to stabilize the process when you start feeling overwhelmed, you start getting concerned about the way you're being treated. A lawyer comes in and helps smooth out those concerns, get you back on track. So here's a good takeaway on how to survive the first 90 days of a work comp claim without regret. Report that injury carefully. Again, I went over it. You need details. You need it in writing. You need to make sure you've gotten it in the hands of the people it needs to get into the hands of, whether that's HR, your manager, whoever that is. And you got to make sure that they're reporting that, because by law, they have to report the notice of the injury to the state of Missouri. So you got to make sure those things are being done. You have to stay consistent medically, right? You have to, from the very first report, you have to describe what you were doing, what the injury was, again, to the best of your knowledge, right? What part you hurt, how you hurt it, where you hurt it, what you were doing. Those are critical from the very beginning. And you can't guess, and you don't want to minimize your injury. If you do that, it's going to be used against you down the road. So again, just report what you know, report it in detail, and don't minimize the problems that you have with this injury. And ask questions early. Make sure you're being kept up to date on what it is that's going on. Make sure you understand what should be going on. And if you don't feel like you're getting the right answers and you feel like something's off track, if you're seeing some of those warning signs, that's a good time to think about calling a work comp experienced lawyer, because your instincts are probably dead on and there's a problem. There's a problem brewing and you're going to run into an issue. And again, this is a time when you're hurt, you can't work, financially struggling, time is not on your side. You've got to get this thing moving, because unfortunately, when a lawyer gets in, it's not a snap of the fingers. You hire a lawyer and the next day everything's roses. It's going to take some time because you got to work through, the lawyer has to work through the system. Things have to be filed. The work comp division has to get things on a calendar. You know, these things have to be sorted out. So again, if you get the first sense that something's just not going the way you believe it should be, it's a good time to reach out to a lawyer and find out, do you in fact have something that should be getting much better care? You should be getting benefits, things like that. So, on the next episode, which will be episode number 3 of this series, we'll talk about how workers' compensation claims end and where most regret lives with injured workers. We're going to talk about what the final stages look like. Once you've made it through all the hurdles of the process of getting treated, maybe being off work, you know, all that stuff, there is an end game. The claim has to resolve, and whether that's by settlement or by hearing, it will resolve. And you need to know some really important things about that part of the claim. So, again, if you missed the first episode, catch it here. And otherwise, until the next episode, be safe and be well.